All right. So we're gonna do property. We're gonna do wills. We're gonna do trusts. We're gonna start with property. Then we'll do some wills administration, multiple choice, and then we'll finish with the trust essay, which I think is a good possibility for you. Property. You'll see from the question and from the little handout I gave you. I chose an area that deals with private land use controls, easements, covenants, license, that kind of stuff, for a couple of reasons. They do like to test that area in essay form. It's just an easy thing to write a question about, number one. And number two, much of what we're going to talk about in that essay will help you for the MBE as well, which again is part of the reason why I printed the handy-dandy little one-page chart that you have. Those of you, there are a few of you who had me for property. You've actually seen it before, and it shows you, as when we get there I'll talk about it, it shows you how to write an essay and also how to think about this subject area. So without further ado, again, because we know we have to get out of here by 6, well, this is a good thing actually, because you all are very eager to go back to your studies, I know. Let's go ahead and if you'll take a few moments to read the question, spot some issues, and then we'll talk about what's in that question. The property one, 2001 property, it's Abel and I don't know who else. At the very end, flip all the way to the end of it, and there's your question. Just read the question. You know, pretend like it's an exam question, read it, and spot some issues, and jot down some thoughts. The very last page, you went too far because you went into trust. So the very last page of the property. There you go. There you go. Okay. Okay, let's kind of wrap it up. I realize on the real exam you should take longer to read the question, but let's go ahead and kind of dive in together. Now, as I mentioned at the start, it's an area that they love to test in essay form because it's so easy to write a question about private land use controls. The good news, if you take a look first, before we even go into the question itself, take a look at the first page of, or the first slide, excuse me, on the one-pager. Across the top, type, creation, duration, scope, transfer, extinguishment. If you're going to write an essay in this area, that's what you do. What kind of easement do I have? How is it created? What's its scope? Can it be transferred? What happens if it's extinguished? Follow this order, and you've written a good essay on this topic. So, it's a separate one page that, okay, thank you, Annabelle. And we made 30 copies, so I don't know where the others are. We don't have 30 people here, so. All right, so let's look at the fact pattern and see how many of these private land use controls we have in this question. It's jam-packed. So it's one of those questions where you're going to see in my answer, I've got more stuff in there than you would write in an hour. And in fact, there is some of what I would normally call negative issue spotting here, just to give us some review and give me a platform for talking about some of the stuff that you want to make sure you know. So we've got Art. He owns Lot 1 on Crystal Lake, and of course it's located in Florida. Always pay attention to the location. Most of the time they want you to talk about Florida law, unless on the occasion, which they've done recently, they want you to talk about federal con law or federal criminal procedure. If they don't tell you location, usually they do, then it's a good idea to say, I'm going to assume it's set in Florida. You don't assume a lot on this exam, but I would do that so that you can tell them that you're going to apply Florida law. And as we'll see, much of Florida law is very similar to what you're learning for the MBE, but there are a couple of places where Florida law is different, and that's why they like to test in this area to see if you're paying attention to Florida law. Here we are at the end of January. If you have not looked at Florida distinctions, and I realize the commercial courses sometimes leave them to the end, make sure you take a look sooner rather than later. You need to know the distinctions, and you don't want to wait to the last minute, because if you do, that's the only thing you'll remember. And then you'll get to the MBE and screw that up, because all you're thinking about is Florida. So Bud is the owner of Lot 2. Now, property teacher in me sees Lot 1, Lot 2. I know where we're going right away. And as I've said several times, let the facts be your guide. They're going to have these short fact patterns like this one, and every fact is going to count. So I'm seeing 2 lots, and somebody's going to be wandering over somebody else's lot. Sure bet. And not only that, Lot 2 is situated behind Lot 1, overlooking Lot 1 to the lake. So you're immediately going to think about what? What kind? And it's a type, possibly a type of easement. What kind? Got to be more specific, right? Looking over the lake? View. Now. Oh, but you can in Florida. There you go. Annabelle's right. Under the common law, you had just 4 kinds of negative easements: light, air, water, and lateral, side, and subjacent underneath support. Just those 4: light, air, water, and lateral and subjacent support. But there's a line of cases in Florida that recognizes an easement of view. Not one of the common law easements, and that's what they're testing here. Now, mind you, any negative easement, by the way, negative easement, I get to tell you what you can't do on your property, right? That's a negative easement. Rather than I have the right to go across your property, that's an affirmative easement. Any negative easement, however, may be created in just one way. What's the one way? What do you need for a negative easement? Always include. You need a writing. Always in Florida you need a writing, which you're going to find you have in this case. So they're testing And probably most of the outlines don't even mention that the easement of view is recognized in Florida. Probably they don't, but just file that away because it is. Lot 1 is landlocked by the lake, and Lot 2. So you know as soon as they tell you it's landlocked that you're going to have some access issue for sure. Yeah, come on down. Come on in and grab a seat. And the packets are in the back. So, thus, ART's only access to the main highway is a dirt road running through Lot 2. So there's your easement, right? But what do you want to be thinking about? If it's landlocked and his only access is, what kind of an easement? Right. It's an implied easement that is based on necessity. But what do you know about common law? What do you know about implied easements? What do you need? 3 things you need for an implied easement always. What's the first thing? And this is basic common law. We got a little variation on theme in Florida, but still, you need initial unity of ownership. Somebody owns the whole big thing. Then you need severance of the unity and what I call the requisite degree of necessity. If there's no prior use, you need strict necessity. If there's prior use, just reasonable necessity. That's a rule that applies in both MBE and Florida. So if that's not sounding really familiar, rest assured that even if they don't test it in Florida, you're going to see implied easements on the MBE. And it's an easy rule to remember. An easement by necessity is a form of implied easement, and so you must have initial unity of ownership and severance. What's missing from this question as far as you can see? Initial unity of ownership. Now, because they tell you it's landlocked, I have a brief paragraph about implied easement, but I say, hey, it can't be an implied easement at common law because there wasn't initial unity of ownership. However, Florida has a statutory easement of way by necessity. That's what's a mouthful. It's what it's called. Statutory easement of way by necessity. And that statutory easement of way by necessity does not require initial unity of ownership. We'll talk about the rest of the requirements when we get there in the slides. Florida law. And if you wrote this question, writing just a good common law answer, you'd be missing something really important. And they love to test the statutory easement of way by necessity. It is a frequent flyer in property questions. So when we get there, take a look at it. It is in your Florida materials, I'm sure, for any commercial course. It's important. It's something you want to be on the lookout for. Okay, neither Art's nor Bud's deed contained any reference to the dirt road, of course, which means that you're talking about an implied easement of some kind because it's not express. In 1975, Art and Bud signed an agreement. Now we do have an agreement by which Bud paid Art $3,000 in return for Art's promise not to build any structure on Lot 1 that would block Bud's view. There you go. That's your negative easement of view in writing. And because it's view, even though it's not one of the original 4, it's recognized in Florida. The document was never recorded. Oops, why do we care? Notice, they love to test recording. Oh, gee. On the Florida essay, that's another frequent flyer. Do we know yet what kind of recording statute Florida has? It is a notice statute, which means that you look for 3 things, which we'll talk about. You got to figure out who is subsequent. You're going to have 2 claimants. Whoever is subsequent, that person has to be a bona fide purchaser for value, usually easy to spot. It's going to be up or down, money or no money. And then 3, who takes without notice, express, actual, implied, or constructive. So, or inquiry from the land. So make sure that you, again, look for those 3 things: subsequent, bona fide purchaser for value, notice, actual, constructive, and inquiry. Now, since 1970, Bud has used the path to reach the lake. He goes across Art's land to reach the lake. But what's missing from that equation? It's not what? thinking about an implied easement. Is an implied easement going to work there, even if there is unity of ownership, which there wasn't? But would it work there, an implied easement? Because it's not for ingress or egress to the lot. It's just to be able to get down to the lake. And so, yeah, it's not even reasonably necessary. So, again, just stop on those. When they give you a fact, stop and say, what's it there for? Because that fact is telling you something very important. And use the facts. The best essays will use all the facts that are given. And that tells you what issues to talk about, the facts. And then in 1975, Charlie, who is the owner of Lot 3 behind Bud, jumps in and starts using the path. Same problem, though. It's not going to be an implied easement. It might be what kind of an easement, though? Prescriptive. There you don't need the necessity. You just need, anybody know how long the prescriptive period is in Florida? 20 years. And even at the time of this question, the 20 years had elapsed. But Art complained, and he posted no trespassing signs. However, Bud and Charlie continued. What element of prescription are they trying to get you to talk about there? Let's stop for a second. Little review. A prescriptive easement is very much like adverse possession with a few differences. First of all, major difference, of course, adverse possession is actually possession of the property. A prescriptive easement, it's use of property. So there's the difference there. Now, when we talk about prescription, you still need come on in, Reggie, the elements. You need possession that's actual, right? It's got to be hostile. Exclusive, not so much. And it's got to be continuous for the 20-year period. What you leave out when it comes to a prescriptive easement usually is the exclusive element. If it's exclusive, some jurisdictions still require exclusive for prescriptive easements, but then it's not the whole world. You can share, and this is how it's usually tested, you can share use with the owner of the property. But again, actual, you can couple the actual with notorious and open. Those all kind of blend together, but then definitely hostile. And when they talk about the fact that he's posting the no trespassing signs and they go anyway, that's definitely showing the hostile element. So use the signs that are given to you in the facts. Last year, Art died and daughter inherited Lot 1. Why do we care? She's not a bona fide purchaser, so she cannot claim protection under the recording statute, but we can tack if we even needed to, which we really don't in this fact pattern. Remember, you can tack on both sides, on the prescriptive side and also on the owner side. And since she is taking by inheritance, you can tack in that situation. Before he died, he told daughter about the agreement. Well, okay, she's not a bona fide purchaser, so she can't take protection under the recording statute. Plus, now she's got actual notice, at least of the agreement with Bud for the view. So she builds a house, an addition to the house, and of course it blocks the view. So Bud fenced off the dirt road, blocking her access to Lot 1. And that's very common in the cases. People get mean with each other. Okay, now, the only thing about this question that isn't really in the new style is the broad call, the question discuss. That's pretty broad. But what I did, you can see here, I focused on the three main things we were talking about. The right-of-way over the dirt road, because Lot 1 is landlocked. The view, which we talked about in the writing, and their right-of-way to access the lake, the prescriptive easement primarily. Now, if you don't have a lot of time, which obviously you don't, there's a lot in this question, you may limit your discussion. You're going to see in a moment that I talk about whether there's an express writing here and other stuff. You can zero in on the ones that are most relevant and don't bother with all the different types of easements that could be raised. Quite frankly, you won't have time to write about all of them. Do some thought beforehand, figure out which ones are most important. So let's take a look. Let me do this way so it's a little easier to see. And as we go along, please do stop me. So it's possible, the three things that are possible for daughter: express easement, implied easement, prescriptive easement. But as I just said, express easement, if you say anything, maybe you say a sentence, because there's no writing. And for an express easement, you have to have a writing. Common law implied easement. Remember again, you've got to have unity of ownership, severance, and requisite degree of necessity. We don't have evidence of unity of ownership. Don't assume unity of ownership. They're going to tell you if there is. And honestly, you can stop right there. No unity of ownership, no implied easement. I went through the other elements just to show you how you would do it, but in the interest of time, just say no unity of ownership, moving on. So let me move past that. Okay, now, we don't need, here's one important point that I want to point out to you. However, compensation, I'm going to come back to that, especially important when you're thinking about the difference between the common law easement, implied easement in Florida, and the statutory easement of way by necessity. Because as you may recall from your property lecture, or maybe from your property class, if the court imposes any kind of common law easement, whether by implication or prescription, or if it is by estoppel even, no compensation is due to the owner of the servient estate. You just have to eat it and let the other person walk across your property. But we're going to see with the statutory easement of way by necessity, compensation is due. It's built right into the Florida statute. A big difference. That's the kind of contrast that you want to draw. So let's spend some time on that statutory easement of way by necessity, because you won't be familiar with it from your law school property class. And has anybody had a Florida property distinctions lecture yet? You have. Did they talk about this? Yeah, good. If you haven't had your lecture yet, then that's maybe why you don't know about it. But it's an important point. It is, again, tested frequently. So here's what you need for your your statutory easement of way by necessity in Florida. First thing is, the parcel has to be located outside a municipality. They don't really tell you here it's on a lake, so I would say, well, assuming that it is outside a municipality, then. They clearly want you to discuss this issue fully, so you have to keep going even though they didn't make it real clear. Second, the parcel, and this one's important, the parcel has to be used for either dwelling or agricultural purposes. And of course there's a house on lot 1, so that element is satisfied. Third, here's the language, and say it any way that you can. The language actually says, so hemmed in that there's no reasonable route of entrance or exit available. So say it's landlocked, you're doing okay. And clearly the facts tell you that lot 1 is landlocked. So the elements of a statutory easement of way by necessity have been satisfied in this case. Assuming, again, that the property's outside a municipality. Here's the key. Compensation is due in this case, and you want to draw that contrast. You want to make sure you say that the common law implied easement, if it even exists here, which it probably doesn't, but if it does, no compensation is due to the owner of the servient estate, but if the elements of the statutory easement of way by necessity are satisfied, compensation is due to the owner of the servient estate, paid, of course, by the owner of the dominant estate, which would be lot 1 in this case. Any questions about this statutory easement of way by necessity, especially because many of you haven't reached it yet?
I have a question.
Yes.
Not about that though.
Okay.
So if we were in the actual exam, do we just touch over the express? It couldn't be expressed, and then we say implied easement, and then we say why it wouldn't apply, and then we go to this one
Yes.
directly?
Yeah. The question is, if you're writing the actual exam, because there's a lot to write about here in an hour. And ideally, if you had 3 hours, you could write about each kind fully, but you don't. So I would quickly say there's no express easement because there's no writing. Maybe you could say in 2 sentences, an express easement requires a writing. That element is not satisfied here because there's no writing. Done with express easement. Implied easement requires 3 things: initial unity of ownership, severance, and requisite degree of necessity. In this case, there's no evidence of initial unity of ownership, therefore no implied easement. So you do it very quickly. Now, however, in Florida there is a statutory easement of way by necessity. Now break it down component by component and do a full analysis. Other questions about this part or up to this part in the analysis? The stuff so far is fairly easy, fairly straightforward. It's just time consuming to write about all of it. Now, could daughter have a prescriptive easement? And notice that we're going to be going through these same types of easements over and over again, so as you go along you can also speed up your presentation by saying elements described above if you want to. Prescriptive easement, it's got to be open, and of course that means that we have something that gives notice to the owner. And daughter's walking back, well, first Art and then daughter. They're walking back and forth over lot 2. So clearly there is open. So again, open just means that you've got notice to the true owner. Actual, again, she's on the land, easy to satisfy. Hostility is key, though. And you may remember in the dark reaches of your mind from your property class that there are 3 kinds of hostility, technically, when it comes to adverse possession or prescriptive easement. Just use the objective test here. That's going to be fine in Florida. So all you have to do is intend to use it as your own. You don't have to know it's somebody else's or be the aggressive trespasser or any of those things. And it sure looks like they were using it without his permission. No evidence to the contrary, so that should be enough to satisfy the objective test. Continuous for 20 years. As I said before, looks like, especially at this point in time, because this is an old question, Art used the property for a long time, but if there's any issue about how long he used it, then you tack Art and daughter together. Easy to do because she's stepping into his shoes. As I mentioned before with exclusivity, there are many jurisdictions just don't even mention exclusivity when it comes to a prescriptive easement. I'm not exactly sure what role it plays in Florida. Sometimes Florida law isn't as clear as it might be. So I would mention it and say, but it's not a big deal anyway, because as long as it's not shared with the whole world, you're probably going to satisfy the exclusivity requirement. And we do not have everybody in the universe tramping over this path. So if there's an exclusivity requirement, it should be good in this case. Now, if we've got that interference, of course, then you can get money damages, injunctive relief, whatever's appropriate in the case. They didn't really get into dollars and cents, so you can't, you don't have to say how much money. That's the good news. Any questions? Yes?
The prescriptive easement for 20 years in Florida.
Yes. Yes. Common law period for a prescriptive easement is 20 years. Florida uses that rule is for sure. Florida definitely uses 20 years for prescriptive easements. 7 years, obviously, for adverse possession. Yeah, and make sure. I'll get your question in a second. Make sure if you haven't looked at the Florida rules for adverse possession, make sure that you do, because Florida has some very specific rules, and depending upon whether you pay taxes, you don't pay taxes, there are some differences. Question. Yeah, and they don't tell you when Art started. So I threw it in just to say, and if for any reason you need it, it's easy here. I'm using the facts because they told you that the daughter took over from Art, so maybe they want you to mention tacking. Honestly, I think the main reason that's in there is because then she can't claim the benefit of the recording statute, but still, I'd throw in the tacking, get you a point or two, probably. Other questions? Okay, so we conclude, and always remember, if you can, I know it's hard, but if you can, tie it up, conclude at the end of each section if you can. A good essay, in the very first paragraph you say, here's where I'm going, here are the issues I'm going to discuss, then here's where I am, your discussion, and then your conclusion, here's where I was. That makes a really perfect essay. All right, so now we go to Bud's view of the lake, starting first with that negative easement, and then the dreaded covenant that runs with the land / equitable servitude. There are, in modern property law, there are very few cases that actually focus on a covenant that runs with the land at law. Why? Does anybody remember from your property class what you don't get with if you prove a covenant? Now, let me back up because it can be useful information for MBE more than Florida. A covenant that runs with the land at law is the older of the two, between these two. It developed first. You had more rigid requirements, and the remedy is money damages. If you're suing for breach of a covenant that runs with the land, your remedy is money damages. And again, store that away for MBE purposes more than Florida. With an equitable servitude, you default, or not default, but you fall back on equitable servitude in one of two situations, which sometimes it may be both. Either you can't satisfy all of the traditional requirements for a covenant that runs with the land at law, or, importantly, you're seeking equitable relief in the form of an injunction. Almost all cases involving this area, the plaintiff is looking for injunctive relief. And so virtually all of the cases are equitable servitude cases. You all, I think, everybody had Duke Veneer, yeah? For property as your case book. There is not one covenant that runs with the land at law case in that case book for that reason. They're all servitude cases. So, you may need to know the difference between the two for MBE. And I have given you the difference between the two in the PowerPoint. But for essay purposes, you could probably just go right to the servitude. That's what we're going to do here, again, in the interest of time, because what is it that Bud's going to want? Does he want money damages? No, he wants to be able to see the lake. He wants injunctive relief. So, however, the negative easement we're not skipping over because we actually have a writing here, and because, again, there is a specific Florida rule that they're testing here. So, negative easement of view. Remembering again, you have your four traditional kinds of negative easements: light, air, water, and lateral and subjacent support. That list doesn't include view. But Florida case law does include view. At least in this case, if it's the person who's right behind the person who has access to the water. And that's the case here. Lot 2 is right behind Lot 1. But you do need a writing. And here we do have a writing. So quite frankly, under Florida law, Bud does have a negative easement of view. And there's no time limit on it. Any kind of easement, of course, can be perpetual. It can also be limited in time depending upon how it's described in the creating document. There's no time limit here, so it's potentially perpetual unless the Servian estate is transferred to a subsequent bona fide purchaser for value without notice. And note, going back to the first slide here, so we say what it is, negative easement. How is it created? writing. Duration, potentially perpetual. Scope, not really an issue here. You would just say view. Transfer. It can run with the dominant estate, but there was no transfer there. But it also runs with the surveying estate unless extinguishment. It's transferred to your subsequent bona fide purchaser for value without notice. But the surveying estate in this case was transferred to daughter. And daughter isn't a bona fide purchaser, as we already established. Now, you could stop right there. You could say we have a notice statute. It protects only a subsequent bona fide purchaser for value. She's not a bona fide purchaser. You can stop and say she's not protected. I added in a discussion of notice here, again, for you to look at if you need it for an essay or certainly for MBE purposes, because notice, of course, especially in the realm of the MBE, the recording questions oftentimes devolve into a discussion of notice. And if you can, try to tackle the recording questions. Spend a little bit of extra time on the multiple choice recording questions that you have in your commercial course, because a lot of people skip over it, kind of like estates and future interests. I don't want to hear about it, right? You can skip over estates and future interests because it's hard and it may waste your time. But recording you can get, and you will get probably at least three or four recording questions on the MBE. You get those questions right, the person sitting next to you likely will not. It's how you pass the exam. You get more right than except unless you're sitting next to someone from St. Thomas, then you're all going to get them right. But assuming, as is oftentimes the case, you're sitting next to somebody from some other school, you want more points than they do. Nickel and dime it. One question here, another question there, you pass, and the other person doesn't. Any questions about negative easement? All right. Now, I don't stop with the negative easement because they do want you to look at the multiple ways that Bud's interest could be created. And as I said, I threw in a discussion of covenant that runs with the land for your study purposes. I would not, on the exam, spend a whole lot of time on it because it's the wrong remedy. So I'm going to go past that, and if you have any questions, though, of course, jump in. But the equitable servitude, when we get there, we want to talk about. Now, you may have learned the elements of equitable servitude a little differently from the way I present it, and your commercial course may present it in yet another different way. Here's why. The law is anything but consistent in this area. And so it's a tough area to try to boil down into, here's the rule. But what I like to do in talking about equitable servitude is to track the requirements for a covenant that runs with the land at law, because that's equitable servitude grew out of that. And you either still need the element or it can be satisfied by a substitute. And so it's kind of, I approach it from that old common law point of view. If you've got a methodology that works, as long as you hit the high points, that's all that matters. So what do we need for an equitable servitude? You actually don't need a writing. We do have one here for the view, but you don't need one. You need intent, though. You've got to have intent to create whatever it is, which is, if you've got a writing, you're going to glean the intent usually from the writing, which was clear here. Now, privity, which is where everybody kind of shuts off and turns off. You do not need horizontal privity, which probably everybody knows at this point. For an equitable servitude, horizontal privity is gone. Vertical privity, you may have learned in your property class that you don't need vertical privity either. There are a few jurisdictions that still sort of do. I cannot tell you a specific Florida rule here, haven't been able to find one. So what I say here is, if it's required, it's satisfied. Because it is, because daughter is in vertical privity with art. I'm not convinced that it's required in Florida. I throw it in because there's no clear rule. Here's the place where you do need, question? Yeah, I would in this case, because we don't know whether Florida has that requirement. And so I would say, well, vertical privity isn't present, but it's possible. I'd say in many jurisdictions, vertical privity isn't required anymore. So that you can go on, because you definitely want to hit touch and concern. It is more important in equitable servitude, than it is at law. Because an equitable servitude is an interest in land. And so touch and concern is very important vocabulary. Interest in land. A covenant is a promise that attaches to land. So you see the difference. The equitable servitude, they say, sinks its tentacles into the land. Touch and concern, very important. What test do you want to use for touch and concern? Use the one, don't use the third restatement. If you learned the third restatement in your property class, it's kind of funky, but don't use it. Use the old test, which is an equitable servitude touches and concerns in the following circumstances. Analyze each side separately, the burden side and the benefit side. The benefit touches and concerns the benefited land if it increases the value of the benefited land. The burden touches and concerns the burdened land if it decreases the value of the burdened land. Translated into this case, does the benefit touch and concern the benefited land? Bud's land is the benefited land. Is his property worth more money if he's got a lake view? Sure. The burden touches and concerns at this point daughter's land, since she took over for Art. Is her property worth less if she can't build up? Yeah, because she can't do what she wants to with her land. So touch and concern is satisfied in this case. Daughter's land is worth less because she can't build her addition, and Bud's land is worth more because to him if the addition isn't there, because then he's got the view. Now, here, notice I'm fast forwarding, aren't I? Because we already talked about it before. Recording statute is certainly relevant to equitable servitudes. But daughter can't take the benefit of the recording statute, as we've already established, because she wasn't a bona fide purchaser. She took by inheriting. So at this point, you don't need to repeat it if you said it before. Just move right on. What remedy does Bud want? If he gets anything, he wants injunctive relief. That's why he's suing to enforce this thing as an equitable servitude. Any questions on Bud? Okay, now we've got their right to use the path. We want to take a look at implied easement, prescriptive easement, and irrevocable license, easement by estoppel. You may recall from your property class, again, since everybody had the same case book, this principle comes out of the case. There was a mine that opened up and built a road across some other property, and then the mine closed, and then people were hooking into the road, and then finally the owner just blocked off the road after somebody spent a lot of money building a house. So what started out as a license, yes, you may cross my property, turned into an easement by estoppel because the other party relied. Don't forget about that, that transition, if you will, because it's easy to work into the fact pattern. All right, so implied easement. There's not much we have to say more about implied easement in this case, because we already established there was no unity of ownership. And if you want to just refer back to the previous discussion saying no unity of ownership, we're done, good enough. And I put the full discussion in here. You do not need to. Oh, statutory easement of way by necessity. We do have to mention it again. Same elements, of course. The parcel is, we'll assume anyway, it's outside a municipality. We'll assume it's used for dwelling purposes because Bud had a house. Is it landlocked? Well, we know Lot 2 is not landlocked because Lot 2 has the exit to the road that Lot 1 wants. Well, if it's not landlocked, it's not so hemmed in. We're done with the statutory easement of way by necessity. But again, using those facts, they definitely wanted that discussion here so that you can contrast the two situations. Prescriptive easement, same elements. What do you think here? Is there anything that would give Bud and Charlie a prescriptive easement? They're walking over the property. It's open and notorious and actual. What element is the one that you really have to think about?
20 years.
Well, the 20 years for sure, and the hostility. They kept going after he put the sign up, no trespassing. So it seems to me that that's good evidence that they were treating the property as their own. Once again, use those facts. They gave you a fact about posting the sign, no trespassing, and them keeping going. You want to make sure that if they've given you a good, juicy fact, that you throw it into your discussion. That's how you pick up points. And then, of course, the continuous for 20 years. Bud's been there forever, and the question is, Charlie, it looks like that's a typo. 126 years. I didn't even notice that before. He's been there since 1975. That's not quite 126 years. He's been there long enough, too, because the question's set in 2001. I don't know what happened there. Just ignore that. But they both, even though that one has been there longer than the other, they've both been there for the 20 years. So you don't even have to get into tacking in this case. Okay. Again, on the exclusivity, not a problem. Let's talk about the easement by estoppel irrevocable license issue, though, because we haven't talked about it yet. Once again, you can start out with a license that becomes an easement, that just morphs into an easement. Remembering first that a license is just a privilege. It's very fragile. It's highly revocable. You just have the privilege of doing something on somebody else's property. And maybe there was a license here. There wasn't an express license, but they were walking back and forth across the property, seemingly with Art's knowledge. How could he miss them, right? So maybe there was a license. Now, remember that Art complained about the noise and trash, but at least at first didn't really do anything about it. And could he have terminated the license at that point? Yes. But until he posts the sign, he's really not even trying to terminate the license. Now, the question becomes, when, if, did he revoke it? Maybe when he posted the sign, no trespassing. That's certainly what he was intending to do. The question, however, is, at that point in time, had it already morphed from a license into an easement by estoppel? So what do you need for easement by estoppel? It's estoppel just like you see any place else. You're not going to have a promise, probably. It's called estoppel in pay, in country. It's going to be by a representation, which in this case may just simply be the fact that Art let them walk across the property. That's sufficient. Then you need reliance. The reliance has to be actual, which it was. They're actually walking across his property, and reasonable. What do you think under the circumstances? Reasonable? Probably. I mean, if you say no, that's fine too, but I think it probably was reasonable because they wanted to go down the lake and see the lake or go fishing or whatever they were going to do there. And then some kind of injustice. Bud was maintaining the path, and so he spent some money. So at least in respect to Bud, I think you probably have some injustice. Harder for Charlie, but you're not going to ban Charlie and let Bud walk, so probably they both get to walk here based on Bud's reliance in the form of reliance damages. He paid money to maintain the path.
Is that enough, though?
It doesn't matter whether it's enough. It's a good question. It would be enough for reliance damages. If Bud just simply wanted some money, it clearly would be enough for that. Whether it's enough to allow the license to morph into a true easement, and for the purposes of this question, it doesn't matter. You can say yes or no as long as you say why. And remember that when it comes, don't beat yourself up on these essays about getting the right factual conclusion. In a case like this, where it could be yes or could be no, it's how you get to yes or no. Obviously, if you're talking about the easement of way by necessity, there's a yes or a no in respect to the path to the lake, because Lot 2 isn't landlocked, nor is Lot 3, because both Bud and Charlie are using it. On the other hand, here, has Bud relied enough to allow for injunctive relief? Whatever you say is probably enough. Questions? Any questions about this question or property in general? That's a vast universe, of course. Going once, going twice on property. Do try to write some property essays. There's a good chance there's going to be property in something that you're asked to write about in February. It may not be a standalone question, but it's going to be there, right? Okay, so we'll leave property behind, and before we take a break, we're going to do the wills administration questions, and then we'll take a break. If we take 2 breaks, we're going to run out of time, and there is a 6 o'clock class. So I'm going to ask you to pull out the question packet, Florida wills and trust questions. I'm not going to do all of those questions with you, partly a time issue, but even more than that, I want to leave some questions for you to do on your own. We will post, questions are actually up there in the box. They should, did you get a full packet? No.
Not yet.
Okay, in the packet. You'll have extra questions that you can do, and the answers will be posted, analytical answers, so my detailed explanations will be posted along with all these materials on the web course. All right, so I am going to start with question number 1, though, so go ahead, dive in, and you all, hang on. Yes, you have your clickers. Okay, so let me start and go ahead with question number 1. And remember, when you get to the, click in. There we go. Anybody else on this one? We're missing a few. Anybody still working on this one? I'm sorry. Okay. Yeah, some of the clickers are probably dead. All right, I'm going to go ahead and call it. Interesting. The answer is C. Now, it is really important, especially if you had Professor Ronner, because she does more UPC than the rest of us do. Don't mix UPC with Florida. For those who do know, Florida has what kind of strict per stirpes? Good. Which means you're going to look for that root generation, not the first generation with survivors. You look for the root generation. Now, let's go forward. Those of you, there are a few of you who had me for wills and trusts, I think, but I'm a big believer in the drawing. So, you put your decedent up top, that's Dan. You draw the family tree. It takes a few moments, but it can make the difference between getting the question right and getting it wrong. So we've got 3 children, Raccoon, Nancy, and Doc. Raccoon has Rocky, Nancy has twins, McGill and Lil, and Doc has Gidgeon, and Gidgeon has Dakota. All right, now, you X out the dead people, right? And that's Dan, and Raccoon, Nancy, and Doc. Okay, yeah. So, Florida, strict per stirpes, again, you're looking for the root generation. The root generation, very important in Florida, is the first generation after the common ancestor. Who's the common ancestor here? In the first parentellum, it's Dan, and because it's lineal descendants. If there are no lineal descendants and you go up to the next parentellum, which is headed by, guess what, the parents, the root generation is going to be what? Brothers and sisters, because it's the first generation after the common ancestor, your parents. Grandparents, it's going to be your aunts and uncles. Always look for the first generation after the common ancestor. They usually go for lineal descendants, that's the good news, but should you get a question involving collateral heirs, second or third parentellum, root generation, and you divide the property into the following parts. 1 part for each person born into the root generation who survives the decedent, Dan here, or who predeceases but leaves lineal descendants. So, look at the picture. We have 3 born into the root generation, potential for 3 parts. They're each dead. So we look to see if they left survivors. Rocky survived Raccoon. McGill and Lil survived Nancy. And Gidgeon, plus Dakota, survived Doc. 3 parts. What do we do with the third that was supposed to go to Raccoon? Clearly, it goes to Rocky. Rocky steps into Raccoon's shoes. The third that goes to Nancy, how do we divide it? 1/6, 1/6. And the third that was supposed to go to Doc goes to Gideon. Dakota takes nothing. Why? Because Gideon is still alive. You never take by inheritance if somebody ahead of you in your lineal line is living. So 1/3 to Rocky. The next third is split evenly between McGill and Lil. And then Gidgeon gets the other third. For those of you who picked B, you took the uniform probate route and you looked for the first generation with survivors. Nope, not in Florida. Remember, it's the root generation. Even if everybody in the root generation is dead, you still take the parts by the root generation. Any questions? Because you will, if you get wills administration, you might not this time, but if you do, you will get a question that's like this. Okay? Number 2. Anybody else? All right, let's see how we did. And once again, you're going to see in this question a difference between Florida and UPC. And I promise you, if you get a question set in this area, that's exactly where they're going to zero in. In a couple of classes, we're going to do Florida evidence. It's the same thing. Where Florida is different from MBE, or in this case, the Uniform Probate Code, it's exactly what they're going to ask you about. So let's see how we did. Pretty good this time. Now, somebody, hopefully inadvertently, picked E. Need I say more? You know, I'll make the speech one more time and then we'll leave it. On both Florida and the MBE, when it comes to multiple choice, you have 4 choices, A, B, C, and D. And should you guess if you don't know the right answer? Of course, because they don't take off for wrong answers. You get a 25% chance for each of those A, B, C, and D. You get a 0% chance for E. There's never an E. E is always wrong, so don't waste your effort picking E. But you guys did well with this one because it appears you were focusing on the Florida rule. Now let's draw the picture because there is also an important distinction that you want to make. And last week I gave my Wills and Trust class a set of problems, and one of them involved half-bloods. And they were confused. And I didn't think it was as confusing as they thought it was. And the difference is between collateral and lineal inheritance. And that's where they got all funked out. All right, so here's our picture. Husband number 1, whoever that might be, marries mother, and mother has a child, Martha. And then husband number 1 disappears. Mother marries husband number 2 and has 2 children, Rita and Bonnie. Now, all 3 in that line up here, they're all dead. So husband number 1 is gone or dead, mother's dead, and husband number 2 is dead. And now our decedent is Rita. So it's collateral inheritance. Rita has no lineal descendants, right? She has no children, no grandchildren, no great-grandchildren. So collateral to the side. Her sisters are to the side. Now we need to know, are they related by the whole blood or the half-blood? Well, look at the picture. That's why you draw the picture. Rita and Bonnie shared both the mother and father. They're related by the whole blood. Rita and Martha shared a mother but not a father. They're related by the half-blood. So here's what you do. Use the formula I'm about to tell you. If you use this formula, people look at questions like this, and I bet you did some of you did practice question that looked a lot like this one, right? So you follow the practice question and you don't think. They change the facts a little bit. Here's a formula that I promise you will get you the right answer. And a lot of people won't have the right answer because they won't use the formula. So you take each person who is a potential heir. In this case, Martha and Bonnie. If a person is related by the half-blood, Martha, you give that person 1 part. You have to do a little math here, unfortunately.
Go again, I'm sorry.
Okay? If the potential heir, Martha in this case, is related by the half-blood, you give that person 1 part. You give them a 1. If the person is related by the whole blood, you give that person 2 parts, a 2. And if you could have 5 or 6 people, you do the same thing. Related by the half-blood, 1 part. Related by the whole blood, 2 parts, so a 1 and a 2. Then you take all the parts that you have, in this case, a 1 part plus a 2 part. 1 plus 2 equals 3. Okay, here comes the fun part for the mathematically challenged. You take the 3, the total of the parts, and that becomes the denominator. And those of you who had me for property, you're going, oh, not again, because when we did conceptual severance, we did fractions. Okay, denominator is the total of the parts, in this case 3. And then you go back to each person, and you take the part assigned to the person, and you put it in the numerator, the top half of the fraction. Ah, it works, yeah. So, Martha, we gave her a 1. 1 over 3, 1/3. Bonnie, we gave her a 2. 2 over 3, 2/3. 1/3 plus 2/3, how many? 100%. It's all there. And I've got a problem that I sometimes use. It's got like 8 different players with different relationships. Use the formula, it's perfect every time. And I'm telling you, a lot of people won't have that formula, won't use it, and if they change the facts up just a little bit, you get the question right, and they don't. Now, and that's the name of the game. I want to point out something important, though, because I'm telling you, my Wills and Trust class, I don't know why, they really got hung up on this part. Suppose in this question that Mother dies after Rita. So Rita's dead, but Mother dies after Rita. So Mother is our decedent. Now we're talking about lineal inheritance, right? Now, Martha to Bonnie, they are half-bloods, right? Now we actually have 2 half-bloods there. Let's leave Rita in there so you can see it more clearly. So we got Martha, Rita, and Bonnie. Mother dies. And Rita and Bonnie are whole-bloods, but Martha's a half-blood. When it's lineal descent, they all take equally. Or, of course, if all you've got are half-bloods, they're all going to take equally too. But in this case, if Rita's living and Mother's dead, and she's our decedent mother, then it's going to be 1/3, 1/3, 1/3, because everybody takes equally. So use the half-blood rule only for collateral inheritance. Any questions about that? Because I promise you also, if you get a wills administration set, that's a likely thing to test again. Reggie?
Who is Martha dead? Rita and Bonnie will take 1/3.
Oh, good point. Yeah, if H1, Mother, and H2 are dead, and Martha is our decedent, leaving Rita and Bonnie, they are related to Martha by the half-blood, but each is related to Martha by the half-blood, so what are we going to do? Half to Rita, half to Bonnie. Because they're all related by the half-blood, exactly. Any other questions on this one? All right, we're going to skip number 3. It's a real simple question, but we're definitely going to do number 4. Okay, anybody else on this one? All right, let's see how we did. If you picked A, you didn't read the call of the question. Can somebody who picked A tell me why you didn't read the call of the question carefully? What does the call of the question say here? Incorrect. And what's interesting here is you all ended up, those of you who didn't read the call of the question carefully, all ended up with A. Usually I get A, B, C, and I see people going, well, but B, and struggling over A, B, and C. They're all right. Now let's look at what's going on here. Billy makes a will, it's validly executed, and then he wants to revoke it. And what's the Florida rule? Can you revoke by a subsequent writing in Florida? Of course you can. Can you revoke by inconsistency in Florida? Yes, you can. Can you revoke by physical act? Yes, you can in Florida if you revoke the whole thing. What's the one thing you can't do in Florida? Partial revocation by physical act, which is D. So if you picked A, which almost half of you did, it's because you didn't look at the call to question. And that should be a hint to you. You're reading too fast. And if you've got 3 choices and they all look pretty good and then one that doesn't look good, that should be a signal to go back and look at the call to question to make sure you read it correctly. Okay? You will not know everything, right? You can't. You're going to have to spot them some questions. But if you know the answer and you blow it because you didn't read carefully, that's when you want to shoot yourself. Those are the kinds of errors that are preventable, and they cost you points. And I don't want to scare you or depress you, but every time somebody ends up with 135.5, you do not want to be that person. Okay? So get as many right as you can. All right, moving forward, because I think everybody understands the rule there, you just didn't read carefully. Number 6. Oh, I didn't. Sorry. You guys got thank you. Okay, click away. Sorry. Not working? Okay. You want me? I'll get you one. Go ahead.
Thank you.
Okay, let's see how we did on this one. Lapse is important, and it has been a very fluid area. Good. Okay. We know the Will's anti-lapse statute, which is good. I'm going to talk a little bit about that, and then I'm going to talk to you about the new trust anti-lapse statute. We've had, I don't know, I've lost track. I think maybe 5 new trust anti-lapse statutes over a period of maybe 10 to 15 years. But let's start with the Will's anti-lapse statute. Okay, first of all, of course, a gift lapses if the beneficiary isn't living at the time the document, the will in this case, is executed, although technically that's a void gift, not a lapse gift. We treat it as lapsed. Or the beneficiary fails to survive the testator in this case. So what you need to save a lapse gift under the anti-lapse statute, of course, is 2 things. First, you need somebody who is a descendant of the grandparents of the decedent. And so that's why A is the right answer, because if Beethoven is Jude's brother, Beethoven's going to be a descendant of Jude's grandparents. So that's number 1, but that person also has to leave lineal descendants who can step into that person's shoes, and obviously Sadie and Mackenzie can do that here. remembering also, just to keep an eye out for the fact, as we'll see when we get to the trust essay, that you can, the testator or the settlor, as the case may be, can take the case outside the scope of the anti-lapse statute very simply by putting a survival condition into the gift to so-and-so if he survives me or survives to such and such date. And so don't forget about that, because you can pull the case outside the anti-lapse statute with survival words that are expressed in the will or the trust. Reggie.
This is why I was getting confused. So that means if in this case instead of will was a trust,
We're going to get there. Yeah. Up until recently. In fact, this is the first time that I'm teaching wills and trusts under the new trust anti-lapse statute. There is a trust anti-lapse statute that took effect July 1st, 2014. So depending on when you had wills and trusts, you might not have discussed the new trust anti-lapse statute. So it's important to note. Under the most recent old trust anti-lapse statute, there was no relationship requirement, right? Sound familiar? For those of you who had Florida wills and trusts, that's probably what you learned. You still had to leave lineal descendants who could step into your shoes, but no relationship requirement, so you could be a friend or whatever. As of July 1st, 2014, Florida has put the the relationship requirement back into the trust anti-lapse statute also. It's the same relationship requirement, a descendant of the grandparents. So you have to, I want to tell you, it's a very poorly written section, and Professor Butler and I have had numerous conversations with people who drafted the statute and said, why'd you draft it that way? And they all say, we wanted to accomplish the following, even though the language doesn't really say it. So what they said they were trying to accomplish is to make them on a par. Wills anti-lapse, trust anti-lapse. And so, for your purposes, you should know that the trust anti-lapse statute now requires those same two things, descendant of the grandparents and leaving lineal descendants who can step in, always remembering you can take the case out of the anti-lapse statute simply by putting a survivorship requirement into the gift, express survivorship language. Otherwise, they're the same. There is one small caveat, something I'll delay till we get to the trust question in respect to the trust anti-lapse statute that's still there. A little bit of extra points, really. It's not going to be significant in most cases, but I'll show you when we get there. Any questions, though? The good news, yeah.
Taking it out means
For example, if it said Jude devises $10,000 to Beethoven if Beethoven survives Jude, the trust anti-lapse statute does not apply.
okay.
Because there's an expressor. That's what you'll look for. There, you could have other language, but it's unlikely that you will. It's going to be express survivorship language, which we'll see in the trust essay. Other questions, though, because it is important. If they, and especially if you get a trust essay, I'm guessing you're going to get some anti-lapse in there. Remember, first of all, it's effective July 1st, 2014, so that's now going to be a year and a half. Enough time has elapsed. Plus, no matter what anybody else tells you about recent changes in Florida law, as opposed to recent changes in MBE law, Florida can and does test very recent changes. I give you a really simple example, but one that threw a lot of people. A few years back, Florida abolished, as you all know, joint and several liability. The statute took effect July 1st. July 20, whatever, they had a torts question with joint and several liability. So you had to know the new law. So some people will tell you, oh, if it's not 2 years old, they're not going to test it. May be true for MBE because they draft those questions so far in advance. Not true for Florida. We've seen it too often. Pay attention to the updates that they give you in your commercial course, so they will tell you what the recent law is. Okay, any other questions on anti-lapse? Again, an important issue. All right, we're going to jump forward a little bit. Again, you'll be able to work through these questions. Let's do number 12. Anybody else? Ah, there we go. Okay. Okay, pretty good. It doesn't really matter who you had for wills and trusts. You probably didn't spend time on this kind of stuff. If you have a wills administration component, will they test this kind of stuff? Yes. So your picky procedural rules kind of thing can easily show up in the multiple choice. So we're talking here about venue for probate proceedings. Remember also, probate goes into which court? Circuit court. Okay? Circuit court, which is the probate court, not county court. Those little things, look for those little things, particularly in essays. Many times, as I've read the essay questions that they give, they throw a court in, and oftentimes it's the wrong court. Doesn't matter what the subject matter is, always check the court. And Judge Shepard, next Friday, will spend some time talking to you about the proper courts. Always pay attention to that. So you're going into the circuit court, and if you have a Florida resident who is the decedent, then you go into the circuit court in the county in which the decedent was a resident. Very simple. But if your decedent is not a resident of Florida, then the first thing that you're going to look for is property in Florida. You're looking for a connection to Florida, right? And you're looking for property, and you can go into any county in which that property is owned. If there's no property owned in Florida, and yet you've got somebody, it could be somebody who executed a will down here for some reason and then moved to another state, but asked for the will to be probated in Florida. You can do that. Or Florida law to be applied. Then your third category, which is C, then you look for somebody who is a debtor of the decedent. In that order, though. First, where the decedent resided, if the decedent was a Florida resident. Second, property in Florida if the decedent is not a resident. And then if no property, then a debtor of the decedent. You have to find some contact. All right. Keeping in line with kind of picky rules that you probably didn't cover in your wills and trust class, number 14. All right. let's see how we did. And just by the by, you notice how short some of these questions are. And when it comes to this kind of stuff, the questions probably are going to be very short. You'll also notice, on purpose, these questions are not in MBE style. That's because, as you probably figured out already, Florida does not write multiple choice questions in MBE style. They can be, it's hard to write as badly as, I hate to say it, but as badly as the Florida questions are written. But you probably already heard that. Commercial courses don't have lots of Florida questions because you sit there, you go, wow, I don't know how to write a bad question like that. And the Florida questions are just bad. Talk to anybody who has taken the exam. They're horrible. And you do the best you can with bad questions. So, answer to this one is, as most of you got, B. Now, there are two sets of rules. And of course, we want to distinguish between a testate and an intestate estate. This one is intestate because it says Debbie decedent died without a will. If Debbie decedent is intestate, then of course you go to the surviving spouse first. If there's no surviving spouse or the spouse is not willing to serve, then you go next to the person selected by a majority in interest of the heirs. And when we say majority in interest, we don't mean number of heirs, we mean share of the estate. I'm sorry?
So it's not going to be the
Heir of the nearest kin, that's your third. You go first to the surviving spouse. Then you ask the heirs to get together, good luck on that one, and pick somebody. If they can't, which is very probable, then the heir of the nearest kinship.
If there is a will and there is no designation of personal representative, then we go to...
Right. If you have a will, the first thing, of course, would be the person designated in the will. If there's no one designated in the will or the person designated is unwilling to serve, then you go to the person selected by a majority in interest of the devisees. Again, share, not numbers. And then if they can't pick somebody, then any devisee. Okay. No questions about that. Then that was, number 17. We're almost done with these, or at least what we're going to do. All right, let's see how we did. Kind of all over the board. That's why I wanted to do this question. You probably didn't cover it in your Wills and Trust class. I don't cover it in my Wills and Trust class. And people don't intuit the right answer on this one. So file this away for your exam. The answer is C, and it makes sense. So if we've closed administration, that means we've done our final accounting, we have paid all the creditors, we have distributed all the property. We're done. And it doesn't matter if you find a later will. It doesn't matter if somebody comes along and says to the court, please, please, please. What does matter, and it makes sense, is if there's newly discovered property, because you got to do something with the property. And so the court will reopen administration, but only on the discovery of additional property. Makes perfect sense when you understand the purpose of the rule, but not for any other reason. And again, file that away. If you have wills administration, it's going to show up in the questions, and it's a rule that most people don't seem to know, and you definitely didn't get in your class. All right, one last question for a reason. Straying over into trust, which isn't usually in the multiple choice, but there's a reason why I want to do it, and then we'll take a break and come back and do trust. So number 21. Anybody else on this one? All right. I wanted to do this question because if there is anything tested more than spendthrift trust when it comes to trust in Florida, I couldn't tell you. They love, love, love spendthrift trust. Part of it's easy, part of it isn't. So make sure when you are reviewing your wills and trust outline that you, especially because you might get a trust essay, you give quality time to spendthrift trust and look for a spendthrift trust. We all know what a spendthrift trust is, right? It protects the beneficiary from his or her creditors, or the interest of the beneficiary from his or her creditors, but of course it prevents the beneficiary from making either the voluntary or the involuntary transfer. So D is the right answer, but we had a lot of scattered choices. So let me explain why D is the right answer here. We have a change in the law, not so recent now. It's been around for a while, but it's a significant change, and particularly if you learned non-Florida law in your wills and trust class, there's a rule that you might have been thinking about here that Florida probably doesn't follow anymore. So we know, again, the spendthrift trust protects the interest of the beneficiary while the interest is in the trust. Once it's paid out to the beneficiary, creditors can scramble, they can get it. But there were a few exceptions. One that was recognized clearly at common law and that apparently didn't survive in Florida is someone who supplies necessities. Common law, someone who supplied necessities could get at the interest of food, housing, something like that, could get at the interest while it was still in the trust, attached to the interest. There are 3 categories in the Florida Trust Code now, and they do not include necessities, probably because they did not intend. It's another case of not great drafting, but from everything I've read and everyone that I've talked to, they did not intend necessities to continue, and I'll explain why in a moment. So what are the 3 exceptions? The first one is D. We take care of our own. Someone who supplies services to protect the interest of the beneficiary in the trust gets to attach the trust. Who's that somebody? Lawyers. We take care of our own. Okay, so that's number 1. Number 2, someone attacking the trust for spousal or child support, but if you picked B, it's because you didn't read carefully enough, because it's only as a last resort. You must exhaust all traditional remedies first. Reading comprehension, right? Gets you every time. And the third is claims by the U.S. or Florida government. And you go, what's that? Well, it could be taxes. But beyond taxes, it was aimed, apparently, at least in part, at Medicaid, Medicare claims. And those are your medical providers, your necessities. So the thought was that those claims for necessities were primarily, when you're dealing with decedents, for medical care, and they would come through the government claims. So that's the explanation that I've read. That's what I've gathered from talking to people. File that away, though, because they love, love, love to test spendthrift provisions. Okay, we're going to take a brief break and make sure that you're back. You know, if you can do 5 minutes, that would be great. Only because, again, we have to be out of here at 6. I will do the drawing when you come back. So if you haven't done your ticket, do your ticket yet. We had some late entries, and please sign in. Okay, let's see what we've got in this trust question. It's an old question, but it's fairly typical of how they test trust. And I will tell you that while they're combining a lot of subjects, and they tell you you can have up to 3 subjects per question, I've seen some questions that sure looks like it's 4 or 5 to me. They still give standalone trust questions. Or like this one with trust and just pro rep tacked on. So be prepared to write a good, juicy trust question. Now, the good news about trusts, if you're going to write a trust essay, all trust essays follow kind of the same arc. First thing is going to be, was the trust properly formed, right? And the elements of the trust, if you haven't reviewed wills and trusts yet, make sure that you get those elements down. We'll be going through them in a moment. Form the trust. Then you're going to construe the provisions and perform the trust. And within that discussion, really important component will be trustee duties. Now, depending upon who you had for wills and trusts, your professor may not have spent a lot of time on trustee duties because it tends to be at the end of the course. Trustee duties are really important. So make sure you review the trustee duties. And then the last thing you'll do is end the trust, terminate the trust. It's nice because it's always the same structure. So let's take a look now at what we've got in this fact pattern, and then we'll go through the various parts. Notice also that here, looking in the question, more like what they tend to do today, you've got pointed call of the question. It says answer X, Y, and Z. So if they tell you answer the following questions, you answer the following questions in the order that they've given them to you, even if that order doesn't sound real logical. But that's how the grading outline is going to be arranged, and so you want to duplicate the grading outline. All right, so in 1992, Susan transferred $400,000, which is our trust race, to Ted and Tammy as trustees. Okay, we've got co-trustees. Never a bright idea. Just a little bit piece of advice to those of you who might practice in the air. You can have 1 trustee or 3, but 2, And same thing with personal representative. All you're doing is setting up disaster. But anyway, that's what Susan did here. Under a written irrevocable trust agreement. All right, now here we see something that reflects probably the old law. It's an older question. You should know, you probably do know, or if you don't, make sure you do know, that in Florida today, trusts are presumed to be revocable unless they are clearly stated to be irrevocable, which is the case here. So once again, trusts of whatever kind are presumed to be revocable, not irrevocable. A very strong presumption in Florida today, reversing the old common law presumption. And you want to be able to throw that in at the beginning of a trust question, because usually it's going to be significant.
So you have to say at the heading, like, the so-and-so irrevocable trust.
It should, yeah. Yeah, it's got to be very, Annabelle is right, it's got to be very clear in the document that it is irrevocable, because otherwise that presumption, which is very strong, of revocability will be there. So here, though, we do have an irrevocable trust. The agreement provided that the income of the trust was payable to Ted for 10 years. Okay, first of all, is it okay if we pay the income to a trustee? Yes. And here's a place where people get confused. I see it. Oh, it's another reason why I like to do this question. Ted is the only beneficiary for the first 10 years. And he's also a trustee. Remember, the hallmark of a trust is a split between legal and equitable ownership. And so people will look at this question and they will say, well, there's no split while Ted is getting. But Reggie's right. As long as there is somebody else, even in the distant future, who has another equitable interest, that split between legal and equitable will be preserved. And they will test that very point. This question is a good example. So remember, always look at all your beneficiaries, no matter how remote, before you determine that there is no split between legal and equitable ownership. Okay, so Ted gets the income for 10 years. After 10 years, the trust was to terminate, with trust assets to be distributed as follows. 1/4 share to Tammy. Okay, fine. She's a trustee, but that's okay. But only if she survives Ted. Oh, what did we just talk about? The anti-lapse statute will not apply to Tammy's interest because we have express survivorship language. Okay? 1/4 share to Bob. And I just want to advise you, when you are writing a question, especially a trust question, but it can be any question, quite frankly, if you see Bob, just give everything to Bob.
What?
Bob always gets everything. I don't know why. I don't write questions that way, but on these bar questions, Bob always, so if you, when in doubt, just give it all to Bob. And as this question was written, the outcome changes under, you laugh, but just look at the questions and tell me if I'm wrong. As under the current law, which is what we're going to apply to this question, Bob doesn't get everything. But under the question as it was written, he got almost everything. I'm telling you, Bob makes out like a bandit every time. Okay, so 1/4 share to Bob. And of course, we have no survivorship language there, so should Bob predecease, which he didn't here, the anti-lapse statute would apply. A 1/4 share to be distributed for religious purposes. Okay, everybody thinks that's not a good gift, but it is. We're going to see, and I'll explain why. The rule has changed a little bit about that particular provision since this question was written, but nevertheless, that broad religious purposes is sufficient. And a 1/4 share to be distributed equally among my friends. Okay. But the rule has changed. Under previous law, that gift would be void as too vague, but the rule has changed. And I'll explain how it has changed, because it will be preserved if certain things are done by the trustee in an appropriate time. So we'll look at that. All right. Susan died in 1995. Ignore the fact that it says Susan died in 1995, because we want to apply the current rules, right? Okay. She leaves, what did I tell you? She leaves her entire estate to Bob, because Bob is going to make out like a bandit, all right? Why do we care, by the way, if she has a will leaving everything to Bob? Because she has a trust here that's supposed to distribute property to other people, but we have to be concerned about what? What word? Lapse or void gifts, or gifts that are not enforced for other reasons. And if they aren't, what's going to happen to that property? We're going to have, what do we call it? A resulting trust. Falls back into Susan's estate and will pass through her will to Bob. So don't forget about that. They work in tandem, the will and the trust. Okay, Tammy died in 1997, but she didn't survive Ted. So her gift will lapse because we've taken it outside the scope of the anti-lapse statute. After her death, Ted maintained a policy of investments of the trust consisting of 90% corporate bonds and 10% stock. Now, today you wouldn't do that type of investment, but at the time that this question was written, it was still an investment that might make sense. Knowing the difference between stocks and bonds in this context actually matters. An investment that is all in bonds is going to do what? Spin off? Not today, but income, right? I mean, once upon a time you would get income from bonds. Benefits who? Who's going to get the income? Ted, the current beneficiary. And an investment in stock does what? Theoretically. Again, maybe not today, but it's supposed to grow the principal, right? Who gets the principal? The beneficiaries on distribution. And so when Ted invests 90% in corporate bonds, who's he benefiting? Himself. So we have a breach of fiduciary duties in the plural. All right? Always letting those facts talk to us. And then they tell you, in case you didn't know, this policy maximizes the income of the trust but minimizes the potential for growth. All right? Again, several different trustee duties that are being violated here. So now Bob comes to you for advice. Can Bob come to you for advice? Can he ask questions about this trust? Yes, because he is a beneficiary. He's got standing. Look, you got a standing question. And it says, can Bob have the trust declared invalid? We're going to look at that. Can Bob have Ted removed as trustee? We will look at that. If the trust is not declared invalid, how will the assets be distributed? And then, of course, the pro rep with the fee, which I will leave for your own discussion. So let's take a look first, as we should anyway, at the validity of the trust. Elements, elements, elements. What do you need? You need a settlor. And to be a settlor in Florida, you have to be, how old? 18. With a will. Important, and I can't tell you why. I think it's a stupid distinction that they should correct. 3 or 4 years ago, they amended the probate code to allow someone who is 18 or an emancipated minor to make a will. But you still have to be 18. You cannot be an emancipated minor and make a trust. Stupid, I say, because a good estate plan today has both. So just make sure you know that distinction. Easy to test. Got to be 18.
Sorry, I get confused with the distinction.
Uh-huh.
You have to be 18 or be an emancipated minor?
To execute a will. To execute a trust, you have to be 18. Yeah. And, of course, competent. But the 18 versus 18 or emancipated, that's the big difference. All right, so you need a settlor. You need a trustee, at least one. You need a trust race. Ascertainable beneficiaries, at least for a private trust. When you have a charitable trust, of course, you do not want ascertainable beneficiaries. And we'll be talking about resulting trusts because we're going to have some failed gifts. You also, I didn't put it there, but for certain kinds of trusts, of course, you need a writing. We had a writing here, so I didn't add it in. When do you need a writing? Easiest. Okay, exactly. Easiest one if it's a testamentary trust, because it's going to be in a will, and a will has to be in writing. But for certain kinds of inter vivos trusts, first of all, if the trust involves what kind of property? Real property. You got to have a writing. Real property makes sense, right? And if under the current statute, if your trust has what we call testamentary aspects, which means it distributes property on or after the death of the settlor, you're going to need a writing because that trust with testamentary aspects has to satisfy all will formalities. Here we have a writing, so I just didn't even bother with it. You could have a sentence that says the trust was in writing and move on. But back up, what's the trust race? $400,000. It does now have testamentary aspects. And so under the current law, you would need the writing. At the time the question was written, you didn't. All right, so let's look at our elements. Settlor, it's Susan. She's over 18. I don't know how old she was, but she was way over 18. I wouldn't spend a lot of time on it. Trustee. All right, here's where I talk about the required split between legal and equitable ownership. And we've got 2 trustees who are named. They can be beneficiaries as long as they are not the sole beneficiary and the sole trustee. As long as there's somebody out there, again, it can be a contingent future interest. And by the way, in a trust, almost all future interests under the anti-lapse statute, almost all future interests will be deemed to be contingent, even if they're not written that way. Just a little something you can throw in to show your knowledge. We don't have the merger. We already talked about that. And of course, a rule that everybody knows, but just don't get carried away with it. A trust will not fail for want of a trustee. The court will step in and appoint a trustee. Just don't go nuts. In this case, when Tammy dies, we don't need another trustee. So the court's not going to step in unless the trust specifically required 2 trustees. And we don't have evidence that it did. It just named 2 people. So, that we discussed. All right. Whoops, I'm sorry. Trust race. Not much to say. $400,000. We're good to go. Trust race can be real property. It can be personal property. It can be tangible. It can be intangible, as long as it's identifiable. All right. Beneficiaries in a private trust must be ascertainable. Okay. Ted and Bob, they're named. They're ascertainable. Tammy, she's named, and she was alive when the trust was created. She's ascertainable. The fact that she died later may affect her gift as a beneficiary, but it doesn't prevent her from being a beneficiary at the outset. Now, religious purposes. Interestingly, again, it's something that you wouldn't necessarily intuit, but a gift, a general gift to charity, religious purposes here would be one of those. You can just say to charity. That gift will be sufficiently definite. What happens, though, is that somebody's going to have to pick the charity. Now, I guess I discussed it later, but I'm going to mention it now and then mention it later. Under the old trust code, the trustee would pick the appropriate charity when you had that general gift. Under the new trust code, the court does. So that's a change. Once,
Could you repeat, please?
yes. If you have a general gift to charity, broad gift to charity, which you have here, under the old law, the trustee picked the charity. Under the current law, the court, the judge, picks the charity. Yes,
What's the
ma'am.
name of that power? If you remember?
I'm sorry, Paula, I just
There's a
couldn't.
name for that power.
It's not cypre. It's different from cypre. We'll get to cypre, but it is like cypre, but it's not the same because there's a different reason for cypre.
Does the trust have to give the power, discretionary power or mandatory power to the trustee to?
Oh, for the trust. Oh,
distribute?
yes. Oh, yeah, good point. The trust could say to the trustee to name certain charities. That's a power of appointment. And yes, then that would take you outside from the court. Absolutely. And every once in a while, it's kind of the unfortunate thing, every once in a while they do throw a power of appointment into the mix in the questions, and that's a tough area. So I don't know how much attention. Most of the commercial courses don't spend a lot of time on power of appointment in the lectures. It should be probably, though, in the materials, the written materials. At least take a look at it. They never go into great detail because it's a complicated area, but you might have just a little touch of power of appointment in a question. All right, so remembering again, though, whoever is going to get named by the court in this case, it's not going to be individuals. It can be a charitable organization, a religious organization. But you can't say the members of that organization. You can't specify the names of the persons.
That's a new law, right?
No. For example, suppose that you wished to make a gift for scholarships, because you're going to be a wealthy practicing attorney soon. You want to make a gift for scholarships for students at St. Thomas Law School, all right? And you want to endow a scholarship. You cannot say, I'm making this gift to St. Thomas for the following 5 individuals. But you can say a gift to St. Thomas for 5 students to receive scholarships. That's the difference. Okay, you can name the charity. St. Thomas is a charitable organization, but you can't name the individual members of the charity, right? Okay. My friends. Now, at the time this question was written, that particular point was problematic because, of course, if it's a private trust, my friends, it would be private. You have to have ascertainable beneficiaries. And I like to say today, it wasn't true at the time the question was written, but, you know, my friends, my Facebook friends, you know, I don't know. It is by itself too vague. However, by statute in Florida, do I have it here? Yeah. Traditional. Okay, let's go to the next piece. There we go. The trustee now has the power to name members of that class by statute. And the trust does not have to express anything here. If it is a gift to a class, even if the class would not traditionally be sufficiently ascertainable, the trustee may choose members of that class to receive the gift. And if the trustee acts within a reasonable time, whatever that might be, those persons will receive the gift. If the trustee does not act within a reasonable time, the gift fails. It's like a power of appointment, even though it's not, going back to your question, Reggie, it's like a power of appointment in the trustee to appoint members of that class. So again, this change is probably, I don't know, 7, 8, 9 years old at this point. But it is different, and it could be different from the rule that you learned in your wills and trust class. Whoop. Okay.
It's never going to fail for lack of ascertainable beneficiaries.
As long as the trustee steps in and does something, yes, it's not going to fail. Correct. That's
unless that class is too broad. I mean, too big, kind of.
Well, no. My friends is pretty big, right? So the
friends, you can see Facebook friends.
Well, right.
You search for that.
I guess what you're asking is, what suppose the gift says to members of the human race. Okay. Well, under the statute, I would say the trustee can step in and name some members of the human race. Trustee couldn't give a gift to a cat or a dog, but anybody who at least qualifies as a living person ought to be someone who could receive the gift if the trustee acts within a reasonable time. Yes, ma'am.
And it doesn't matter whether it's the trustee that you've assigned and the trustee that gets it if that trustee not available?
Right, correct. That's correct. If you have a replacement trustee, that's fine. Yeah, as long reasonable time, whatever that would be. But yes. Yeah.
So we still mention the traditional rule, and then or should go.
Well, it's a good question. And when the rule first changed, I would. It's been around long enough. It wouldn't hurt to mention the traditional rule, but if you're pressed for time, at this point, since the statutory change, as I say, was 7, 8, 9 years ago, you don't have to at this point. Recent changes like the trust anti-lapse statute, I would mention both because the change is so recent. Use your discretion and use, look at the available time because that's always a question as well. All right, now, if Ted doesn't act, doesn't name the individuals, then you have that resulting trust, which of course is not a real trust. And let's make sure we know the difference between a resulting trust and a constructive trust, because that gets tested a lot. With a resulting trust, the property always falls back to the settlor or the settlor's estate. With a constructive trust, you push the property forward to the person who should have gotten it. And oftentimes based on some kind of fraud or something like that. Doesn't have to be. Constructive trust, the key is some kind of unjust enrichment, but it's very often coupled with fraud. In this case, if the gift fails, it falls back to Susan's estate, and of course passes through her will to, guess who? Bob the Bandit. All right. Now, what about removing Ted? We want to know where, what court. It's always a good, even if they don't specifically ask about the court, throw it in because it's always relevant. Which court is the proper court? And standing, of course, is important here. And then we're going to look at the grounds for removal. And if we need a replacement trustee, a replacement trustee. So, what court? Remember again, it's the circuit court. And anybody who's got an interest in what's going on, so that's the settlor, a co-trustee, a beneficiary, can request the court to remove a trustee. The court can also, of its own initiative, remove a trustee who has been misbehaving. So pretty much anybody except your casual observer can seek removal of the trustee. Bob's a remainder beneficiary. He clearly has standing because he has a beneficial interest in the trust. Now, why? Here's where we get into those trustee duties. And as I said, if you didn't spend much time with them in your trust class, which is certainly possible because you have to cover an awful lot in a 3-hour wills and trust class, make sure you review this area. So, first things first, a trustee must be a prudent investor, because that's one of the biggest jobs of the trustee, to invest the trust race and to manage the investment of the trust race. So you're going to start by saying prudent investor, which means the trustee just acts like a prudent investor. The good news is, under Florida statute now, the trustee can use the resources and the assistance of a professional investor. That delegation of the duty is fine as long as there's proper supervision. Here, that's not an issue, but you can see that show up in a lot of fact patterns. Okay, diversification, very important. As I mentioned before, there is a duty of diversification, unless the trust directs otherwise. There's one question from maybe it's 2004, 2008, I can't remember, a while back now, in which the trust document specifically directed the trustee to put all of the funds in one asset. If the settlor says, here's how I want you to invest, then the trustee follows the settlor's direction. The trustee also, under the new statute, can petition the court if the trustee is concerned about diversification for a valid reason and thinks that a particular investment is really appropriate. The trustee can petition the court and get permission to step outside diversification. And in this market, that could happen. In addition, if for any reason the trustee doesn't diversify, but it benefits the beneficiaries, what are they going to do? They'll ratify. So remember to keep all those things in mind. But here, Ted clearly didn't diversify, putting almost everything into bonds, and his reason wasn't a good one. It was to benefit himself. So he has definitely violated the duty of diversification. There is a corollary duty, the duty of impartiality. They oftentimes go hand in hand. They do in this question. Because the trustee has a duty to treat all beneficiaries equally, or as equally as possible. Once again, the trustee can petition the court, particularly if you've got a beneficiary who has unusual, extraordinary needs. But otherwise, all beneficiaries need to be treated as equally as possible. Well, of course, Ted blew that, because who's Ted benefiting? Himself, not the remainder beneficiaries. Well, in this question, Ted has violated at least 2 major trustee duties. He has failed to diversify. He has failed to be impartial. We don't have any self-dealing or anything like that here, but always be on the lookout, of course, for self-dealing and conflict of interest. So he can be removed because it is a serious violation. What about a replacement trustee? If Tammy had still been around, there would be no need under the trust as it's stated to name a replacement trustee. But since Tammy's dead, you got to have somebody as trustee. Court steps in and appoints a replacement trustee. Pretty easy in this case. So Bob can have Ted removed and replaced. But if for any reason, and the timing gets a little funky because it's an old question now, if for any reason Ted still has some time left on the 10 years for his income interest, the fact that he has violated his fiduciary duty and can be removed as a trustee does not affect his ability to receive his beneficial interest. They are 2 completely separate things. So don't mix and match. He can still get his income for 10 years even though he has violated his fiduciary duties. Yes, ma'am.
And the court appoints a new one, or?
Yes, the court appoints a new trustee.
The court, not the beneficiary?
That's correct. For the replacement, by statute, the court replaces the trustee. Yes, sir.
But he can be sued for damages for his violations, right?
Oh, sure.
And then can that money be taken out of his share of the benefit?
The reason I'm going like this is because we need to know whether there's a spendthrift provision.
If there's not, like in this case.
Yeah, there isn't. Then they could attach his interest, yeah, in the
Once he
trust.
gets it. Oh, no,
No, they could probably attach it in the trust as well under the circumstances of this case, because obviously he is liable for what's called a surcharge. He's liable for damages. It's called a surcharge. It just means damages for breach of his duty. So that's a good question, actually. All right. Now we got to distribute the assets because we're winding down the trust. Remember, you make sure the trust is properly formed. You construe its provisions, which we did. You talk about trustee duties, and then you terminate the trust. The good news here is they did not get into all the different ways that you can terminate a trust. Complicated. Try to get some handle on it because it is actually a fairly frequent flyer. But today we don't have that issue, so let's look at distribution of the assets. Income to Ted for 10 years, the quarter share to Tammy, quarter share to Bob, and the quarter share to religious purposes and my friends. All right, starting first with income to Ted, we just said he gets the interest. And notice the property and professor and me cannot resist. It's a presently possessory equitable term for 10 years. If you can use the vocabulary, extra points. If you can't, get the idea across, right? But make sure you call it an equitable interest because it is an interest in a trust. And he gets it, no matter what. 1/4 share to Tammy. Now, I did not waste time talking about the anti-lapse statute here because it's so clearly a survivorship requirement. If you want to put one sentence in saying, and therefore the anti-lapse statute doesn't apply, it's probably not a bad thing. But do not spend time, if you have an express survivorship requirement, do not spend a lot of time on the anti-lapse statute. My guess, however, is that because of the change a year and a half ago, if you get somebody who doesn't survive, you're probably going to have to deal with the anti-lapse statute to reflect the new change. So Tammy's out of luck, and of course then we have a resulting trust, right? Back to Susan's estate, and that quarter goes to Bob the Bandit, okay? All right, so Bob gets that quarter share. Bob's interest, easy. He's there, no conditions, he takes. So now Bob already has a half. But notice what I wrote there. I did mention the trust anti-lapse statute here. Bonus points. You can get by without it, but bonus points if you can remember it. Bob's interest looks very much like a vested remainder. He's ascertainable, no conditions preceding. Under the trust anti-lapse statute, they did not change this provision when they made the recent changes. All interests in a trust are deemed contingent to the date of distribution. So what happens is you take that contingent remainder, that vested remainder, and you treat it like a contingent remainder. Just throw that out for you, just to be thinking about it. If you can remember it, bonus points. The other thing, however, to remember, good bonus points, maybe not so hard to remember here. Remember, we're distributing the trust, or ending the trust. Is the interest of these beneficiaries equitable or legal? In this case, it is equitable, not legal, because the trustee has been directed to distribute the assets. If the trustee has duties specified in the trust, distribute the assets. When the trust terminates, the interest of the remainder beneficiaries will be will be equitable, not legal. Bonus points again, that one easier to remember. You want to sound like you know what you're talking about. But in any event, Bob did survive. Bob's getting his, well, we're assuming he survives Ted, because he's got to survive to the distribution date. He's going to get now 1/2. Now we go to religious purposes. Once again, we have a change in the law in terms of who gets to do what. Under the old law, the trustee made the selection, now the court does. It is not quite the same as cypre, which isn't actually applicable to this question. The cypre power in the court comes into play in one of two places, very related places. Either the named charity, so you're going to have a named charity. It could have said here to charity ABC, and at the time for distribution, charity ABC is no longer in existence. Then the court will use the cypre power if you have general intent, and use the cypre power to find a charity that is as near as possible. Or if the charity is in existence, but the gift is not large enough or right for the particular named purpose. An example involved, a Florida case involved a gift to a hospital to build a new building, separate building, not just a wing, but a separate building, hospital building for kids. By the time they got to the distribution, there wasn't enough money to build a separate building. And so the hospital said, can we just name a wing in our existing building and make it for the kids? That would be cypre power. But I got to add in, not relevant to this one, but certainly relevant to testing. In that particular case, the court ended up not being able to use the cypre power because there was a gift over. In the event that the new hospital building wasn't built, the money went to a different charity. And so the court had to honor the gift over to the other charity. So don't use the cypre power if there's a gift over in the event of failure. Okay, but in any event here, it's just a gift to general charitable purposes. The court steps in and makes the gift, all right? And of course, understanding that the gift has to be consistent with whatever charitable purposes you can glean from the settlor. Hard to do in this question because we don't really know. Okay, my friends, once again, traditional law, that gift fails. Bob the Bandit would have ended up with 3/4 or at least half and probably 3/4 of the trust. But here we have a new rule. As I mentioned before, the trustee now gets that power of appointment as long as the trustee or the replacement trustee acts within a reasonable time. Reggie?
Is that important to write about that Florida has adopted the common law, the RAP, and say that we have to vest within eternity?
Yeah, you know, you could throw in some of my answers. I throw it in. I didn't even bother here because the interests were so clearly valid under RAP. But just as a reminder, one sentence on RAP is not a bad thing. Here's the rule in Florida on RAP. For trusts, it's 360 years. Why 360 years? The banking institutions asked for 360 years. It's 4 times 90, which was the old statutory rule against perpetuities in Florida, 4 times 90, which means, honestly and truly, for an interest in a trust created after the date of the new statute, which now is a long time ago, I can tell you that I'm not going to be around in 360 years. Perhaps some of you are going to live a little bit longer, but 360 years, it's somebody else's problem. So, and that's the gist of it when it comes to an interest created in a trust. But an interest created outside a trust in Florida, you still go back to the 90 years. And that 90-year rule, I'm not going to go into all the details now because we could be here for a half hour, but that 90-year rule is still important in termination of irrevocable trusts. Certain kinds of termination are available if that 90-year rule has been satisfied. Again, I'm not going to go there now. So for trusts, you could have a sentence saying 360 years, not going to worry about it. Here it's so clear that nothing here would violate even the common law rule, that I didn't even add it. But one sentence, not a bad idea. Don't spend a lot of time on it. Okay, so then, I have a little summary, always good to wrap up if you've got the time. And then you would do your professional responsibility component, which in the interest of time we're not going to do today. questions about trusts, though? Anything that you want to ask at this point in time about trusts? Yes, sir.
So, just in terms of the exam itself, you say you have a pretty good feeling at this time.
I'm thinking trust. Yeah, I am. Yep. It's kind of high on my list. Don't shoot me if it's not, but
Yeah.
I think it's a good possibility. I would be prepared for trust. I would.
And con law, Florida con law. Right?
Florida con law. Now, when we say Florida con law, they've been expansive. They have had federal con law a couple of times recently, and they tend to clump when they go into federal con law. They clump it, and so you'll have 3 or 4 exams where it's Fed, and then they go back to Florida. So don't be surprised if you see federal con law. My instinct would be Florida, though, because it's been off for 2 exams. So I really think Florida con that would be actually on the very top of my list, which is why, again, I want to urge you to sit in on Judge Shepard. And of course, Monday for Professor Nathanson for the Civ Pro. And just as a heads up, as you're kind of, you can go ahead and pack up. Everything from today posted on the LexisNexis web course, including the recording. For Professor Nathanson, he likes to have it done through his own website. So I'm not going to be posting any Civ Pro except for a link to his website. But all his stuff, and some of you may know, any of you have him for Civ Pro? He's got a ton of stuff posted. And he'll talk to you about that next week, so all of his materials will be available to you through his website. Okay, that's it. If there are any more questions, we'll see you all, or at least see some of you next Monday for Professor Nathanson.